Please the court, my name is Wesley Stone. I was appointed by this court to represent Mr. Rodgers when his trial counsel moved to withdraw, I think, for personal reasons. I would reserve, based on the number of waiver arguments, 7 minutes for rebuttal.
We do appreciate your taking the appointment and representing this person, so thank you.
Thank you, Judge. Mr. Rodgers was convicted of 2 counts of aggravated assault and 1 count of especially aggravated kidnapping by a Knox County jury. He was represented by Christian Stadler. I did not represent Mr. Rodgers in the trial court below. The site for Mr. Rodgers' convictions relate to what we have referred to as a residence or a home. An inoperable van in a private parking lot, albeit potentially generally frequented by the public at large, but a private parking lot where Mr. Rodgers had lived for approximately 1 year. And there is a video as it relates to the motion to suppress of Officer Lyons. It's a very good video of this van, this home. And what the court can take away from that, as we've said in our brief, is that it was adapted for overnight accommodations. There is tinfoil all around the windows to try to maintain a degree of privacy. There appears to be a canopy or a tarp that's on the back side of that, perhaps a porch of some kind. It was where Mr. Rodgers lived, in the thrift store parking lot, while he worked at the thrift store. Mr. Stadler filed a motion to suppress the evidence found in the van, and the evidence found in the van was a baseball bat. And when the court watches the video, I think that the description by the state of Tennessee that Officer Lyons was able to observe this bat in plain view potentially may be inaccurate. What did happen is Officer Lyons goes to this home and the 2 side doors are open, and Officer Lyons, with the body camera on his chest, is debating whether or not he can get in this van because he thinks the bat's in there, but he doesn't know, so he's trying to figure out how to get in this van. He's on the phone, he's talking to people. Do we have consent? We don't have consent. Because Mr. Rodgers is somewhere else. He's away from this home. And he's debating, can we get in this van? Can we get in this van? We don't have consent, talking to people. And then he leans into the van. He leans so far into the van that his body camera is inside of the van. And he uses a flashlight. And I recognize that it is difficult to capture everything, what one can see visually with their eyes and what's on a video. It would be hard to see this end of this bat that they say. But anyway, they seize the bat and they charge him. With those 3 counts of aggravated assault. It's our position that the trial court erred in finding. It did find that Mr. Rodgers did have a subjective right of privacy, but it was not one that society is willing to recognize as reasonable. Citing that it was a public parking lot, which there was no proof that it was a public parking lot. In fact, it was a private parking lot, and that the van was left in some state of abandonment, and there was no proof that Mr. Rodgers was not squatting. It's our position, based on the HADL factors in our brief, based on our argument in the brief, that the trial court erred in suppressing, or in denying that motion to suppress the baseball bat.
Well, so, did Mr. Rodgers own the van?
No.
Did Mr. Rodgers own the parking lot?
No.
And the parking lot is open to the public. Maybe owned by somebody else, maybe owned by the people at the thrift store, but clearly they open their parking lot to the public because they want the public to come to their store, correct?
Yes.
Okay. And so he doesn't have ownership of the van. He doesn't own the property on which the van sits. Where's his expectation of privacy? Because he can't invoke the, hey, this is a private parking lot, because he doesn't own that parking lot.
The issue that we take with the reference to that we make regarding private parking lot is it's not a public parking lot. It's probably generally frequented by the public at large, probably available for a DUI, all of those things. But he had maintained that as his habitation for a year. My suspicion is, this is not bore out in the record, but my suspicion is that somebody, knowing there's a thrift store there, brought a dilapidated vehicle over there, and Mr. Rodgers got this job, saw the van, and started living in it for a year. He excluded others from it. He did not give consent to search. Officer Lyons respected that absence of consent. Even I think Miss Hodge, the victim in the case, even said that she believed it was his home. So based on the fact that he was residing in it, it's our position that it was a place where he had an expectation of privacy. That's how you get there. It's how, and we think we've demonstrated that in our brief, both plenary review and plain error. But I'll address that perhaps in rebuttal. But at any rate, I think the bigger issue that I want to talk about as it relates to this part of the argument is the sentencing issue. And we've addressed this in both the lead brief and then the reply brief. We have set forth the authorities of why we believe this court, that this issue is available for plenary review for this court. Title 40, Chapter 35 sets forth all of those, and we've set those out. But it's our position that 7 convictions bearing offense dates occurring before July 1st, 1982 were used to increase Mr. Rodgers' range from range 1 to multiple offender as it relates to especially aggravated kidnapping and persistent offender as it relates to his aggravated assault convictions.
But wasn't there a stipulation to his range or an agreement?
Yes.
Okay, so how do you get around that?
And if I may explain how that agreement came about, the prosecutor made those representations. Mr. Stadler agreed to those, and the court did adopt that and found beyond a reasonable doubt that he was persistent and multiple offender, as I've stated. How we get around that is what we have set forth in our brief, that in the amended motion for new trial, number 1, Mr. Rodgers did allege that the defendant's sentence was excessive in light of the totality of the circumstances, number 1, and number 2, that the sections that we have cited in Title 40, Chapter 35, do make that available. And number 3, the states relied on Guerin's, which was an opinion by Judge Greenholtz, saying that, well, if you agree, that's it, you know. But if the court reads that opinion, and we've cited the language in that brief where it does still require this court to review the record and confirm that it supports what the trial court has done. And so it's not just carte blanche if 3 people agree, the judge, the defense lawyer, and the prosecutor agree and get it wrong, that this court cannot consider it. So it's our position that that's how I don't necessarily know that we get around it, but that's how it's available for this court's review and consideration. So it's our position that Mr. Rodgers was improperly classified as to the ranges set forth in the brief, range persistent offender for the aggravated assault convictions, and multiple offender as it relates to this especially aggravated kidnapping. If I'm doing the math correctly, and if you follow Judge Sanchez's sentencing structure, applying correctly Title 40, Chapter 35, Mr. Rodgers' sentences his maximum sentences would be 25 plus 6 would be 31, and his minimum sentence would be 15 plus 3, and so that'd be 18 years, and he's facing a 40-year sentence. So it's our position that his sentence was excessive, as alleged in the amended motion for new trial and as set forth in our brief and reply brief. So if the court has no further questions, I'll yield the time. Of course, the other two issues, we believe we've sufficiently set forth those before the court for relief on those. So it's our request that the court, at a minimum, grant Mr. Rodgers a new sentencing hearing with a correct application of Title 40, Chapter 35, and at a maximum, give him a new trial. Thank you.
Morning, General.
Good morning, Your Honor, Your Honors. May it please the court, counsel, my name is Will Lundy and I represent the state of Tennessee in this appeal. I think I should probably start this morning with the sentencing issue that the defendant has attempted to raise here. The defendant waived any question about his sentencing range by stipulating to it in the trial court. The trial court said, the trial court explicitly asked the defendant about his sentencing range, and the defendant explicitly agreed to it. The trial court asked defense counsel, with respects to count 1 and 2, the Class C felonies of which defendant was convicted, would you stipulate that he is or agree that he is in fact a range 3 multiple offender? Defense counsel responded, yes. And then when it comes to, I'm going to try and skip down here. And the same thing was true with the other offenses as well, and the just the sentencing ranges that had been set forth. This is something that the trial court explicitly asked the defendant about, and the defendant agreed.
So is the state's position that if the defense counsel and the defendant and the trial court read the law incorrectly and stipulate to something, that cures the fact that they read the law incorrectly?
I mean, I think under Guerin's, I think when we have an agreement like that, where it's an express agreement that yes, this is the correct sentencing range, then yes, that's a waiver of that claim. And then on that point, Your Honor, if the defendant wants to raise that issue, then we're here under plain error. Then that's one of the reasons why plain error exists, is to address claims where maybe we have waived them in the trial court. The problem here is that the defendant did not raise plain error in his brief, and so because the defendant did not raise plain error in his brief, the state asked this court not to review the issue at all.
Well, I want to stay on this for a second. I get, obviously, in a plea agreement, all the parties agreeing you're not really range 2, you're range 3. I mean, you're not really range 3, you're range 2, but we're going to sentence you as range 3 at lesser years, to work out a deal, and everybody agrees to that. And even though that's not that he doesn't classify as that, that is truly an agreement, right?
That's correct.
A stipulation of, hey, I'm looking at your pre-sentence report, and it looks like to me that you are a range 3. Do you agree with that? And they say, yeah, we think so too, and they're wrong on the law as to whether those convictions amount to the correct convictions to make you a range 3. Does not seem a little different to you than a plea agreement where we all know that this doesn't count, but I'm agreeing to it anyway, versus, yeah, we think that's right, and so we're just going to go with it?
There is a distinction there, Your Honor, yes. I don't think it's necessarily a relevant distinction. I believe the Guerin's, in Guerin's that the state cites in its brief, I believe that was a trial, just like this was a trial. And in Guerin's, the court was very, very clear. If you want to object to these things, you have to object to them. The state has a burden of proving the sentencing range as a matter of law. That's the state's burden. And if the defendant wishes to put the state to its burden, he must do so. And so, again, by stipulating to the range, the defendant has waived the issue. And I did file a notice of supplemental authority, I think yesterday. I don't know if you got it or not. This court, another Judge Greenholt's opinion that came out on Friday, so it is just hot off the presses. But in that opinion, and you can read it, it's
Probably a pretty
niece.
long opinion too.
I don't think it's particularly long, no. But it is a further example of Judge Greenholtz's quest to clarify issues related to waiver and plain error. And in that opinion, I'm sorry. In that opinion, Judge Greenholtz, I think his analysis is quite good in Nice, where he explains why, if plain error is raised for the first time in a reply brief, that the court just shouldn't consider plain error. And essentially what it is it doesn't give the state the opportunity to respond to the arguments the defendant actually makes.
His argument basically is they've sandbagged you, right? Is that
Right.
they should have known in their principal brief that this is a plain error issue.
Right.
They didn't, and it allowed you the opportunity to respond. They didn't. They've now raised it in a reply brief where you have no opportunity to respond.
That's correct. And I actually felt pretty vindicated because I've argued in my brief before this came out that the defendant has a right then to respond to the state's brief and say, here's why this is preserved, and I disagree on that point. And that is what Nice says, is that the defendant retains the right to argue that. Now, to be honest and to be clear, Nice doesn't say we can't review for plain error when you have something that was raised for the first time in a reply brief. It doesn't say that. It says we're not required to. We may decline to review, and the state is asking this court to decline to review it here. And even if this court does review the sentencing issue, I think Gerens is simply dispositive. The defendant certainly can't establish a breach of a clear and unequivocal rule of law because this issue was waived. And I mean the Gerens case is on all fours here. Again, it was a trial, and the defendant stipulated to the sentencing range as he did here. I just don't see a meaningful distinction between Gerens and this case, and therefore the defendant can't establish a breach of a clear and unequivocal rule of law. Going back then to the Fourth Amendment argument, the defendant did waive this argument as well by failing to raise it in his motion for a new trial. The defendant claims, well, I raised it orally at the hearing on the motion for a new trial, but the law is very clear that in a motion for a new trial, if you want to raise an issue, you have to raise that issue in writing. And if you raise it in orally, you have to reduce that issue to writing within, the correct time frame.
Did the trial court rule on it in the motion for a new trial?
The trial court ruled generally and just denied the motion for a new trial. The court did not specifically rule on this issue, no. At least that's my recollection of the record. So you can look in the record, and see it'll speak for itself, but I don't believe that the court ruled on it explicitly. So the defendant waived this issue by failing to raise it in a written motion for a new trial. It's not anywhere in either the original motion for a new trial or in the amended motion. It just doesn't appear. And besides that, the defendant cannot establish the breach of a clear and unequivocal rule of law. With regard to standing, I'll start there. This court considers multiple factors. I think there's 7 of them that this court looks at. But specifically here, the question is whether the defendant had a possessory interest in the place to be searched, whether he had a right to exclude others from that place. It is conceded the defendant did not own this van. In fact, the defendant did not even know who it was who did own the van. The record is not clear exactly as to who owned the van. I believe the state asked the defendant a question, and in that question, the state said the name of the person who owned the van, but that fact isn't testified to, so I can't say that for sure. In any event, the defendant admitted that he didn't own that van. And also, he's in this parking lot. The defendant didn't testify. I mean, even if he had been living there for a year, he didn't testify that he had permission from this thrift store to be squatting in a van behind their store. He didn't put on any testimony from any owner of the thrift store saying, yes, we've given this person permission to live in this van behind our store so that he can work here. And it is the defendant's burden to establish that he has a reasonable expectation of privacy in the place to be searched. And the defendant just failed to do that here, and the trial court correctly ruled on that. Additionally, another factor is whether the defendant took normal precautions to maintain his privacy. And I will agree with my friend, the van certainly does have aluminum foil all over the windows, but the door was standing wide open in the middle of the day in this parking lot behind a thrift store. The defendant just did not take the normal precaution of closing the door to conceal its contents from the outside world. And so, again, I don't think that the trial court erred when it found that the defendant lacked standing to challenge this search. And even if it did, I do contend that the plain view exception to the warrant requirement applies here, and that the officer properly obtained the bat out of the van.
What's your take on the video?
My take on the video is twofold. First of all, I want to say that the officer testified that he did not stick his head in the van, that his head never crossed the plane when he saw the bat. The video, he's right about what the video shows. The video does show the officer kind of poking his head in. The trial court, just because it found that the defendant lacked standing, it made no findings of fact on that question. So it didn't say I accredit the officer's testimony or I accredit the video. It just didn't weigh those things back and forth. It didn't need to because of the standing issue. But regardless, that would be a legitimate question of fact. Did the officer, poke his head in the van, which is more credible? I would posit that it's not necessary to, the body camera video may not show the bat at the same time that the officer saw the bat. He may have seen it before he poked his head in, and then poked his head in, and then went in to get it. So I don't know that the video is dispositive, and because of that, I think the plain view exception does justify the search here, and so there's just no plain error. I think I'm going to move on to this claim about the right to present a complete defense. That's a constitutional claim, and that constitutional level claim was never presented below. It wasn't in either the motion for a new trial, the amended motion. The defendant didn't raise this issue about this certified judgment of conviction and even the victim's testimony. He just didn't raise these issues in terms of right to present a complete defense. That just didn't appear in the trial court. The defendant waived it, and for the same reasons that I've argued from Nice earlier, I would ask this court not to review it because the defendant did not raise the plain error issue in his brief to this court. On another point on this, I looked this morning, I did not see that certified judgment in the record, so I don't believe that judgment is in the record on appeal. I don't see how the court can review that issue without that certified judgment. And additionally, the defendant didn't voir dire the victim here as to what her testimony might have been. There's just no evidence to support this claim. The defense counsel made some assertions, but the assertions of counsel are not evidence. So really there's just nothing to support this claim here. And even if there was, essentially defense counsel admitted that what he was going to offer was this judgment of conviction from March, which was earlier in the year. This offense happened in June, and he conceded that, if this Mr. Holloway had committed a domestic assault against the victim in this case, that any injuries would have healed, and there's just no nexus, no relevance to this case there. And before my time's up, I think I will just talk briefly about the sufficiency of the evidence. The defendant was convicted of 2 counts of aggravated assault. One was aggravated assault with a dangerous weapon or a deadly weapon. The other was aggravated assault by strangulation. The victim testified that the defendant struck her with a bat. She had a bruise on her arm to prove it. And that's sufficient to prove that the defendant committed aggravated assault with a deadly weapon. The defendant doesn't make any argument that a baseball bat's not a deadly weapon, and clearly if it's used and swung hard enough at someone, it can be. And with regard to the aggravated assault by strangulation, the victim clearly testified that the defendant choked her into unconsciousness repeatedly. And so, again, the evidence is sufficient on that count. And then with regard to the especially aggravated kidnapping, the defendant claims that the confinement in this case was simply, I'm going to try and find the language, excuse me. That it was essentially, it was just part of it was only there to facilitate the assault, and that's just not true. The defendant held the victim captive here. The evidence shows that she was held captive for 12 hours. He wasn't, beating her the entire time, and so the confinement was not merely incidental to the assault. It was If anything, I think the assaults may have been a little more incidental to the confinement because he beat her and to keep her there in the van. So the evidence is certainly sufficient to prove the defendant guilty of especially aggravated kidnapping. If the court has no further questions for me, I would ask this court to affirm. Thank you very much.
Thank you. Thank you, General. Mr. Stone?
I'll just respond by taking this in the order of the state. Regarding the sentencing issue, and here's some of the questions, I think Judge Dyer's questions. The state got it wrong, defense counsel got it wrong, and the trial court got it wrong. And I pointed it out. And the state now wants this court to get it wrong again. And I'm asking all three of the members of this court, at a minimum, I'll take two, but I'm asking all three. Get it right. It's simple.
Which two do you want?
It doesn't matter.
Okay, just checking. That's a good one.
But I'll take two.
Okay.
It's an error. I won't say any more than that. And it's true. I didn't raise it. I didn't argue plain error in my lead brief because the Tennessee Code tells me that it's an appealable issue. So, with that said, I want to then speak to Judge Dyer's comment because when I read, I think it was Nice that was provided yesterday. It's about sandbagging, and if the court reviews the brief in this case, I recognized that there is the preservation of the standing issue could have been preserved better. But recognizing that, we did argue plain error on that issue in our brief. We argued plenary review and then plain error review. So at any rate, we didn't sandbag on the sentencing issue. It's just wrong. On the Fourth Amendment issue, I have to admit that the Fourth Amendment issue was not. Oh, let me back up before I get to that. The motion for new trial, the amended motion for new trial, did raise the sentencing issue that the defendant's sentence was excessive in light of the totality of the circumstances. That's volume 1, page 90, 91. Moving on to the Fourth Amendment, here again we did argue plain error. We think it's available for the court's consideration. I'll defer to the court's review of the video on this plain view exception. It's our argument that there's no way he would have seen that baseball bat other than sticking his body halfway in that home. On the issue of the complete defense, volume 1, page 90, paragraph 3. The defense was denied the opportunity to question the victim witness about the nature of an ongoing relationship the victim had with an unrelated party, Mr. Holloway, who was not a witness for the state in the instant case during the relevant time frame, which was unfairly prejudicial to the defendant, : the expected evidence elicited was not intended for the establishment of a character trait, that's sub A. Sub B, the expected evidence elicited would have been intended to establish a reasonable doubt for the source of the bruising photographed by the police and used at trial. We believe that issue was properly preserved. We don't think that Nice precludes us arguing about plain error in our reply brief. We thought it was properly preserved, and we briefed it. And I will tell the court on the issue of this judgment of, I'm not sure who the judgment was. I don't know if it was Mr. Holloway's or if it was Ms. Hodges. I don't know. During the jury out hearing, trial counsel said, I'm going to offer, I would offer a judgment. I would offer a judgment, certified copy of a judgment, which leads me to believe he didn't have it. So he didn't really, so nothing was ever introduced, so don't waste your time looking for a judgment, it's not in there. I mean, I'm telling you, it's not in there. But I do want to make this comment about that while I still have a little bit of time. There's a lot of to-do on that issue of Rule 608B. I'm not ever going to tell this court that that judgment, whatever it was, should have been introduced during the trial of the case. It's extrinsic evidence. It's just way out there. What I can say is it should have been introduced and considered by the court in determining whether there's what's the standard, clear and convincing evidence of the prior act, wrong or crime or whatever that standard is under 404B in the Shannon Christian Act. It should have been introduced for that purposes outside of the record for the jury's consideration. But anyway, I don't want that red herring on this 608B thing to lead this court astray. That should never came in, but it should have been used in the determination of whether there was clear evidence that the other crime, wrong, or act had occurred. Be that as it may, we would ask this court to, at a minimum, remand this case for sentencing to get it right, and at a maximum, remand this case for a new trial. Thank you.
All right, thank you, Mr. Tom.
Unless you got questions, unless there's questions. Okay, thank you.
And General Lundy, thank you both, and we appreciate the good arguments and excellent briefs, and we'll make a decision on this in due course. We got two more this afternoon, is that right? Yes, Mr. Clerk? All right, well, we'll be in recess till 1:30 then. Thank you.